Hello and good morning, everyone. Welcome to our monthly Startups in the Law series hosted by JonesKertz. We have Kyle Kurtz here today, and he will be going in depth on best practices when starting and growing a venture and how the law affects startups. If you have any questions for Kyle today, please feel free to leave them in the comments below. And a quick reminder, these sessions happen once a month, so if you found them helpful or you think others might too, feel free to spread the word. So without further ado, I'll bring up Kyle and let him take it away from here.
Awesome. Thank you very much for the introduction and welcome to Startups in the Law. I believe that this is the 13th or 14th month straight that we have done this presentation. Just to give you a little bit of word on what this presentation is about. We are talking about legal stuff today with respect to startups, with respect to tech companies, with respect to venture capital transactions, contracts. But this isn't a sales pitch. We're not going to sit here and give you the top 10, best ways to talk to your lawyer or anything like that. This is for educational purposes. This is to help you grow and help you learn and understand some of the ins and outs and some of the perspectives that we as lawyers take when we are negotiating deals, when we are doing transactions, when we are growing companies and helping the founders and the people who run those companies grow them. So, without further ado, I'll get right into it with some introductory slides to give you a little more information about us. We're just two lawyers at the moment, though we do have support staff. I've got two law clerks. We have an office in Oklahoma City, which is actually currently where I am at the moment. I'm here meeting with my business partner to discuss some other stuff for the firm. And Matt Jones is based in Oklahoma City full time. He has an office in Oklahoma City, and a little bit of explanation as to why his email is slightly different than mine. In the state of Oklahoma, we go by the name we go by the name Verge Law Group. In the state of Texas, we go by JonesKertz because the state of Texas does not allow us to use a law firm trade name, which is what Verge Law is. That said, we are still the same law firm. We are still the same practice, I will say too. Me and Matt do the exact same thing day in and day out. And so if you have a question for either of us, or you're located in Texas or Oklahoma and are looking for somebody more local to you, get in contact with us both and let us know how we can possibly help you or answer any questions. Okay. Feel free to write these emails down if you have any questions for after the webinar. Obviously, some of the stuff I'll be talking about may not be, as focused to what you want to learn about today. If that's the case, actually feel free to drop a comment into the comments box here on this webinar, and Capital Factory is going to help me field some of those questions by bringing them up on the screen. So we'll try to address these in real time. I'll try to give some space in this presentation to allow us to be able to answer those questions right after we address certain topics. So one of the, this is the real reason why we do this. I mean, like I've said before, better education equals a better foundation, which leads to more successful startups. That's really the end game here. So to give you an idea, we see, you probably heard the statistics that 9 in 10 businesses will fail, right? We're not really talking about tech startups when we say that. We're really talking about business in general, right? But when it comes to tech startups do have a high failure rate still, because they are growing so quickly, because they are spending money so rapidly, and because they're doing things with the hopes of creating exponential growth. And part of our job as lawyers is to facilitate that growth by making sure that along the way, those companies are protected. So, we oftentimes actually, we rarely, I'll tell you, rarely ever see a company of ours fail. As a matter of fact, in the last year, the only company that has failed because they had a large commercial real estate lease, and it was just drowning them in the middle of the pandemic when they were trying to earn money. And that was the only company that has ever failed that we have ever helped start, or even really helped with engaging in contracts or other transactions. So, we firmly believe that, when you have legal service and, competent counsel for a startup from the outset, you are that much better off. And, a lot of people say, well, I don't have the money for that. There are a lot of people who are very reasonable when it comes to how much they charge for legal services, and they won't make you pay through the nose. I would encourage you to try to find those people so that you can actually put one of these people in your corner, the same way you would put, another professional like a really good accountant, and other people that you might rely on for other services that you can't do yourself. So aside from that, though, we're going to address some basic stuff related to, legal and startup news, capital raises, which is really important. This is, a similar format to the last two we've done, and I'm really going with a part 3 on this because each time I have discovered, new questions. I've discovered, new things that people want to know. And, in the last month, we've had a lot of important capital raise stuff come up to the point where we really do need to address it, because it seems to me that some people are having the same exact questions, and it's just happening, it's just happening in mass, and we're finally getting to address some of the stuff. So, and then last but not least, if we get to it, corporate governance, but that's, really boring compared to capital raise stuff. Anyways, legal disclaimer, obviously, unless you are a current client of mine, I am not your lawyer. This is not legal advice for you, and it's not legal advice for your business. So please do not act on the info until you have sought out the advice of an attorney, and somebody that can actually advise you with respect to your situation. Keep in mind, we frame everything based on the facts available, and we conduct research to reach legal conclusions. We rarely, if ever, make a decision off the top of our head. We rarely, if ever, do anything that is not counseled by the law itself. We sometimes know what the law is off the top of our heads, but we always make sure we go and get that statute. We always make sure we go and get that case law, or at least read up on it before we make certain decisions if we have not ever done it before, right? So just keep in mind, unless you are a lawyer, remember that you are not one. I see a lot of people who draft their own contracts. I'm not going to say that's okay when you're bootstrapping. I will say, a lot of people get very lucky. It's not to say that some people aren't, better at it than others. I have certainly seen better work product from people who are not lawyers. But that said, taking a stab at your own contracts, there's a saying that goes, the person who represents himself as a lawyer has a fool for a client. Don't be one of those people, or at least don't be one of those people for really too long at all. Okay. Aside from that, let's get started. So you've probably heard some rumblings in the news about Biden's proposed tax plan, right? And this is, obviously subject to change. There's certain things that, they're looking at doing with respect to the corporate tax rate and raising it. You might have seen in the news that he had Biden had a little bit of a slip of the tongue, and he basically said, I think he meant to say, if you make more than $400,000, you're not going to pay any more in taxes, or if you make below $400,000, you're not going to pay any more in taxes. Apparently, what he actually did say was, if you make less than $400,000, you are not going to pay taxes. That is not true. You are definitely still going to pay taxes. Everybody who earns income, unless you are in the very, 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 very lowest tax bracket, are going to have to pay something in taxes, and they will not get it all back in a refund. They're looking at raising, the top individual federal income tax rate from 37 to 39.6%. And it appears that the corporate tax rate is going to be somewhere around 25 or 28%. There is one Democrat that actually does have apparently the tie-breaking vote as far as figuring out where the corporate tax rate is going to be. And that person is using quite a lot of leverage to actually keep it lower, surprisingly enough. I would have thought they would have just agreed to 28%. To be honest with you, 28% in taxes is really not a lot when you realize, how much money a lot of these people are making and stocking away, especially with, the 21% tax rate being where it is. That said, we do love it when the tax rate is as low as possible, because the reality is people get to keep more of their money. They get to invest more of it. And what you see when corporate tax rates really go up is you see people spending more money oftentimes than not. And the reason for that is to keep the corporate tax rate, to keep their tax rates as low as possible. so that they don't go into those upper tiers, right? There is some interesting stuff related to the estate tax exemption. They're saying, the estate tax exemption would drop by about 50%. Really what this means is that, let's say you are going to inherit some property, and usually when when somebody dies, if they have a trust set up, if they have an estate plan, then technically, their heirs get a step up in basis, which means that they take ownership of whatever property gets transferred to them as if they owned it at the fair market value of what it was today, right? So they don't have to pay tax on any appreciation in real estate. Typically, they don't have to pay tax on appreciation in stock or anything. What this would effectively do is repeal all of that, which is a very contentious issue, obviously, because there are a lot of people who have worked very hard to amass wealth, and they would obviously like their families to enjoy it. That said, something that every law student learns pretty much in the first year of law school is that when it comes to property law and the transfer of property with respect to inheritance, we try to make sure that we are not creating a system of perpetual wealth, right? We don't want to create a system that allows for people to perpetually basically give money away to their heirs and amass wealth over hundreds or possibly even thousands of years if their families go for that long and are that sustainable. We try, and part of that was to get away from the royalty. Like, I mean, if you look at the kings and queens of that used to exist in Western Europe, or Eastern Europe, really, for that matter, and throughout other parts of the world, that was effectively what was happening. These people were amassing wealth, and it was being passed down from generation to generation, and none of the wealth was really transferring hands. None of those people were being taxed on any of it, and so over time, we as human beings sort of decided that that's really not okay. So in a way, this actually does go to that mission. But at the same time, what we anticipate will actually happen with this is it's probably going to increase the rate in which people are going to do what we call inter vivos, transfers, meaning these people are going to be still alive, and they'll probably sell their homes to their next of kin. They'll probably sell their assets that have a ton of value to their next of kin, so that the people who own 3 houses, like their heirs, don't have to sell one of the 3 houses in order to basically inherit their parents' property. So that said, we're not estate planning lawyers. We do not really do a ton of tax counsel. It really is very specialized work, the type of thing that you have to have gone to additional school for and obtain an LLM in tax to really do well. What I will say, though, is we do advise from a tax standpoint and educate people based on what we know and have spoken with accountants about when it comes to structuring businesses. And so at some point in the future, it may make sense where you're going to be paying more in taxes if you're a corporation than if you were an LLC. At that point, we may be making some changes to the advice and sort of pulling back on fully endorsing corporations because the tax rate could be too high. That said, we won't be doing that anytime soon. That's just something that we're going to be looking out for in the future. Cannabis legalization. So if you haven't heard, really we are at the point where a preponderance of states have either legalized marijuana medically or legalized it recreationally. As a matter of fact, if you're in the state of Texas, we are now in the minority as far as states go that have not done really anything with respect to legalization of marijuana. Technically, hemp is legal, but it's not the same, obviously. And hemp has its uses, but I would say hemp is probably not as well. I would say not probably. Hemp is not the cash crop that marijuana is. Marijuana has billions in more market value from a national and global standpoint. And the world really is moving toward legalization. I will tell you, if Texas does actually legalize the sale of cannabis and the possession of it fully, or just medically, there is going to be an explosion in new business. I don't know if anybody of you have been to Oklahoma recently, but since Oklahoma shares a border with Texas, what you should be aware of is that the moment it went legal here is the moment it was just off to the races to get licenses, to get set up. There were people who had opened within, a month or two, which begs the question, how the heck were they growing it? Where did they get it? Well, really what ended up happening was the black market went onto the white market. And most people who had grow ups that were already existing just got licenses to operate them finally. And I expect that that's exactly what will happen basically, unless there's some really strict legislation that comes across with respect to grow ops, with respect to transporting the product, with respect to obtaining seeds or something like that for it in Texas. But in reality, we are looking to this as, I personally believe, regardless of what your politics are, regardless of how you feel about this, the one thing that is so true about this is that, Canada is miles ahead of us by now, and we are just so far behind the rest of the world when it comes to legalization. We actually probably just need to federally legalize this so that we have a federal regulation regime, and so that we have an ability to actually engage in interstate commerce with respect to this stuff, and so that the states start actively trying to make their state the best state to grow and sell marijuana. That's really what needs to happen. We're just leaving billions, if not trillions of dollars on the table from a market standpoint. And it's just really, it's, a little bit anti-capitalist, I'll say, when you're looking at, legalizing this, and so many people have just not done it yet in any capacity, really. So aside from that, though, I do want to talk about some interesting stuff. So we actually, I don't personally do this because I'm a Texas licensed lawyer, but our Oklahoma practice actually does cannabis law, at least a little bit. And I will tell you, we do represent cannabis investors, startups, and entrepreneurs. We actually have seen certain rules. So, each state's laws has to tackle the problem of people from out of state investing into companies that operate in the marijuana space and have licenses and things like that. Part of the licensing process, you are required to have at least one person who is an Oklahoma resident, and only 25% of the company in Oklahoma can actually be owned by somebody who is a non-resident or an entity that is not an Oklahoma entity. And really, but the problem is this law was actually not that well drafted. So when you put a restriction like this, there are two fields of thought, right? The idea is the law says what it says, and it doesn't say what it doesn't say. The other perspective is the law only says this, but it didn't say I couldn't do this. And so when it comes to this 25% rule, how people are getting around it, what they're doing is they're buying up 25% of the equity of the companies and then agreeing to a profit share, which is actually kind of innovative. That's literally what we call a loophole. These are always LLCs, by the way. They're never corporations. Doesn't appear that they really want to be subject to corporate law or corporate regulation in any way, which I think is smart. These businesses are going to be run, more close knit. They are going to be more closely held. So it doesn't make a ton of sense for them to be corporations unless they really are, part of a large conglomerate or a really large business. But even large businesses can be LLCs. There's really nothing against that. And then, when it comes to the licensing, apparently it's been a bit of whack-a-mole. Obtaining a license in Oklahoma used to be stupid easy. Apparently it's very difficult now. And usually the people who are applying for a license are basically saying, or the people who approve the licenses will just flat out tell you you're not getting a license until I've told you no one or two times, or maybe even three times. And these people are really just not really following the law. They're not following their own regulations. They're sort of making it up as they go. It's kind of the Wild West out here, but I will tell you, when you drive down the street, you can clearly see how much money is being pumped into that industry. It's almost, in my opinion, oversaturated. And, while it does have its own culture, I mean, the one downside is, these things are on every corner now. So, I thought it was, a lot better when there wasn't, a smoke shop on every corner, but at the same time, not something you can really do anything about unless you have some legitimate reason, similar to the reasons for preventing certain advertising for cigarettes, to stop people from advertising in certain ways. But the one thing I will say, by the way, if you're going to start a cannabis startup, don't pick a state-centered name. There are so many Oklahoma cannabis companies that their name is some offshoot of something that is only particular to Oklahoma. The way you need to be thinking about this thing is a brand unto itself and will eventually have trademark protection, which, by the way, you can't get trademark protection if you're a cannabis business. It's not allowed yet, because it's not federally legal. But at the same time, I mean, if you're going to pick a brand name, make sure you pick something that somebody wants to acquire. Don't make it something that you can't trademark. Don't make it something that is so focused on the region that you are unable to really move that brand, across state lines. You want people to be able to identify it across state lines, which I think is the major weakness of a lot of the companies here. They just have not gotten creative enough with creating names, have not focused on marketing well enough to be able to create a brand that will last, more than 10 years. Aside from that, I'm not really going to talk about this much more, but as far as legalization goes in Texas, there's only like two suppliers that you could purchase, high potency THC from, and it's extremely strictly regulated. We actually don't even know how those people got licenses to sell it. We think there's probably something going on behind the scenes that was semi-corrupt, because the state effectively, when it came to this Compassionate Use Act, created what was basically a state sanctioned oligopoly, in that they basically made it so that only two people can ever operate in this space. It's not a monopoly because there's not one, but there's not just one. But at the same time, these people control the entire market. They control the prices for it, and they control the supply for it. So kind of goes against free markets, kind of goes against all concept of demand and supply and demand. That said, this is the only step they've taken yet. Though I think they will be taking another step soon. I'm kind of just hoping that somebody else replaces the current governor so that it can be legalized. I think the current governor is far too conservative for us to expect that he will actually legalize cannabis in the near future. Anyways, do we have any questions about that? It's definitely something that we are interested in, and I'll tell you, the moment it goes legal in Texas, we will be doing that stuff, and we will be doing a lot of it. That's for sure. All right, well, so we're going to talk about capital raises and securities laws today, but I'm not going to bore you so much with the securities laws aspect, except for a couple of things that I do need to talk about. All right, and this is something just off the top of my head that I want to talk about right now. In the last 3 weeks, we've been asked twice if someone can do what is basically a brokerage fee, right? And we look at when you're looking at raising money for somebody, obviously it can cost a lot of money, it can take a lot of time, and so people in some cases want to be compensated for that. Now, the proper way to be compensated when somebody is raising money is either you reward the person, such as the CFO of a company, for having helped raise that money by giving them additional stock, because in that situation they were provided a proper incentive. It's a bonus basically, and it's a non-cash bonus. It's not something that comes out of the money that has been raised, so it won't be seen as a commission, it won't be seen as a brokerage fee, it won't be seen as a finder's fee or anything like that. And then, there might be, some step up in salary in the event that person ends up getting fundraising, because at that point, the business is a little more well capitalized. They may have said, I'll take less money, take more equity right now. Once we do get funded, we'll shift that dynamic, make it so that I make a little more money and a little less equity or something like that over time. There are various ways to do it, but the thing you must know about this is that you cannot agree to a brokerage fee to pay somebody a brokerage fee if that person is not a licensed broker dealer. We encountered that situation with a client of ours the other day, and it was worded in such a way that maybe there could have been an argument. Some lawyers may have argued, though probably unsuccessfully, that that was not a brokerage fee. That was just bonus compensation. It's really a brokerage fee, right? Even if you're calling it, a bonus in that situation, you're taking it, and if you're taking it and tying it directly, percentage amount to the total amount of fundraising, then you're effectively creating a situation where you're creating an illegal, brokerage fee, unless that person has indeed disclosed that brokerage fee in the agreement for investment, which is required, and then has the proper license to do it, which getting a license for it is really not easy. Okay. The thing to keep in mind with that is you are for sure breaking the law if you do give somebody a brokerage fee and you do not disclose it, and that person doesn't have a broker dealer license, right? It is a serious problem. To give you an idea of just how problematic it can be, the current Attorney General for the state of Texas, Ken Paxton, is currently being prosecuted for a felony, which, obviously not something to be proud of if you're from Texas. If that case has been in limbo for like 5 years. Apparently what he did was he sort of played as a finder and took a finder's fee in a certain amount of the investment that was made in this private company. And at that point, when the investor found out about it, they said, you didn't disclose it. You aren't a broker dealer. That's illegal. They literally, went straight to the SEC with it, filed a complaint. And then the SEC decided that they would levy criminal charges against him for doing it. It has always been the case. It has always been his position, which I think this is the stupidest thing on the planet to do. It has always been Ken Paxton's position that that was not improper and that he never did anything wrong. In that situation, the SEC does not necessarily care what your position is. They're going to prosecute you anyway. And as a matter of fact, since he's a lawyer, if he does get convicted of a felony, he's going to lose his bar license. You simply cannot practice the law if you have a felony conviction for securities law violation, which is, a very serious crime. Actually, it's really the only way of criminalizing fraud in that situation. So just keep in mind that, like, whenever you're raising money, you always want to make sure you're raising it in the proper ways. You want to make sure that your compensation structures for the people that are helping you raise, whether those people are advisors or the CFO or the CEO or the board members who can contribute, quite a lot to the fundraising efforts of the business. Just make sure that their comp structures are structured properly so that they're not improper brokerage fees. Does anybody have a question about that? Because it really is, extremely important that we catch those things early on. If you have done those things and you think you did something improper, and that we correct it, that we notify some people that, hey, something wrong might have gone down here, that we give the money back if we need to, because it's impossible. I mean, it's impossible to shield you from liability if you don't correct it. So aside from that, we're going to get right into this from I'm just going to talk very generally. We always do private offerings, right? We very rarely do public offerings unless we're doing, crowdsourcing or crowd fundraising, right? I kind of dislike crowd fundraising, mainly because, if you go on Seed Invest or if you go on one of the other websites, in some cases, those people are not the best partners for that. And really, it's kind of like, it's still almost, like a private offering in some cases, but you're almost filling out the exact thing you would be filling out if you were doing an IPO. And some people just wonder, why am I spending so much money to do something that is exactly the same as what I otherwise would be doing? And also, you have to keep in mind that with, these public offerings for these tech startups that are not true IPOs, if you are doing something like that, the people who are going to be beneficial owners of your business are not going to be, strategic owners. And that's unfortunate because ideally as you grow, especially you get into the seed and series A, if you get institutional capital in and you get large checks in, you would very much prefer that the people who have, all of that money are probably going to be taking a board seat or, taking a vested interest in managing the growth of the company and managing the development of the executives and the officers who grow it, especially if those officers are still co-founders, right? So just keep in mind that private offerings, in my opinion, a little more ideal. Public offerings are still growing in terms of how many public offerings are being done, especially with crowd fundraising websites like Seed Invest. But at the same time, we're not being we're not being old school by saying we should do private offerings. We're actually being very pragmatic and practical when we say, it's an easier way of raising money, and it really is in some cases. And also, we're not creating a situation where we have tons and tons and tons of investors, which is, it could be very difficult. You can create a lot of potential liability with a public offering inadvertently if for instance you did not do the cap table correctly and you didn't figure out the ownership structure correctly. So I would just keep in mind that you're creating additional exposure with the more people that you allow to invest in your company, but we minimize that exposure by making sure that we're properly disclosing everything, we're properly calculating the ownership structure and how much each individual investor owns at that time. Really, when we look at securities law exemptions, securities law is the law of exemptions. We want to be exempt from having to register this thing as a public offering. I will tell you, Rule 506B is the most common, though Rule 506C is becoming a lot more common lately. And actually, I think it will, if it hasn't already, it will actually, the balance will actually shift to where Rule 506C is more common. Because with Rule 506C, you can actually advertise, you can actually promote the investment online, and you've probably seen Instagram ads, you've probably seen Facebook ads, where people are selling portions of their business and they're telling you straight up how much they're selling, right? That's a great way of doing this. When it comes to you get a lot more exposure, you gain a lot more steam, and you're probably more likely to actually get press releases out there. You're probably more likely to get press from people in the startup world, and people who are the investors who are more likely to contact you directly as opposed to the other way around, right? Especially if your business is really gaining steam and it truly is a viable venture. That said, we file Reg D, which for anyone that's properly done a securities, a sale of securities, in the United States, you're gonna have to file Reg D, and you'll that'll be discoverable to potential investors. They'll be able to go search for it to see if you've actually done that. So I would encourage you to make sure that your lawyer does that for you, and pays all the fees necessary if there are any fees that they do have to pay for filing certain securities filings. Also, when it comes to blue sky filings, if you're doing stuff that is exclusively within a certain state and you don't sell to anybody else who's a resident of any other state, then technically it doesn't necessarily fall under the purview of the federal government if you don't want it to. And in those situations, you can potentially just file what's called a state, blue sky filing, as opposed to filing Reg D. That said, most of the tech startups that we deal with are gonna file Reg D. They're gonna file what's called Form D, and Form D is now all online. It used to not be. But yeah, and this is not something that you as an individual really need to worry about. I also would not try to do that yourself. It's actually the government system for filing Reg D and obtaining the central index keys so that you can go file Reg D is extremely cumbersome, and it's not intuitive really at all. And then on top of that, it's like it looks like it's run on 1999 furniture store level software. It doesn't look new, and it certainly is not approachable unless you've done it before and been handheld through it. And there are other exemptions that we can go through. Reg CF, obviously, if you're doing crowdfunding, they actually raised the max private offering amount for that up to 5 million. So that's why I say it looks like there's a lot more traction when you consider that you can raise $5 million. Well, putting that online, allowing people to do crowdfunding, that makes crowdfunding a lot more viable, right? If we're only allowed to raise $1 million, then as was the case under the previous rule, what would have inevitably happened was everybody who got to the Series A stage would have never used crowdfunding because they could have never accessed it really, or they would have had to structure it in some way that makes very little sense. For example, they would have basically had to set up one or more subsidiary LLCs, and every single time they reached $1.07 million, they would have had to start another LLC, rework all of the documents to reflect the new name of the LLC, and then they would sell an additional offering up to $1.07 million and do that until the fundraising round closed. Obviously, that's not an ideal way of raising money. That's actually very stupid, in my opinion, because you're just creating additional levels of exposure. Those LLCs are actually, when you're looking at it from a fraud standpoint, if any aspect of that transaction could ever be accused of being fraudulent, then they're just going to merge all those offerings into one. They're literally going to consider the LLCs all the same LLC, because you will have effectively, it's just not. I will tell you, it's just from a legal perspective, I don't see that there actually being a ton of benefit there when you do it that way. That said, instead of Form D, you'll file Form C with that. And then Reg A, we were actually asked about Reg A by one of our clients. Tier 1, 20 million, Tier 2, 75 million, which was increased up from 50 million. It's commonly used in real estate crowdfunding. When you look at commercial real estate is the only asset aside from a company stock that could really have tangible value of 20 million or more. And so it makes a lot of sense, if you're, and well, by the way, Tier 1 is up to 20 million. It's not just 20 million. And so you're looking at, the ability to do general solicitation. That said, when you do general solicitation, by the way, everybody talks about, are these investors accredited or not? So basically, are these individuals high net worth individuals? Are they millionaires? Do they make $300,000 a year, basically? In that situation, we actually have to collect a lot more information. Whereas if we're doing a Reg D compliant round and we're raising under Rule 506B, we do not necessarily have to, have them fill out all the questionnaires under the sun. With Rule 506B, we can just have these people check the box and sign their name. And we have people do that all the time. And basically that's them making a representation that at the time of signing, I am wealthy enough. I am, I have net income high enough, or I have, assets in the amount that are required. And we don't have to follow up. We don't have to get a bank statement. We don't have to look at anything else. I have actually, though, I'll tell you, with Rule 506C offerings, with Reg A offerings as well, where general solicitation is allowed, we actually have provided verification letters to certain individuals. And I'll tell you, in some cases, they're like borderline, right? I actually, almost had to turn somebody away the other day, but we found out that, okay, because this person owns, investment real estate, because of the extreme increase in real estate values in certain parts of the state, and especially the particular areas in which that person held real estate, we were able to in a way calculate that, okay, this person actually is indeed has net worth in excess of $1 million. And it was because the real estate itself had appreciated so much over a short period of time that it really sent them over the top. So, there are certain arguments that can be made that someone is an accredited or not an accredited investor. We just have to make sure we're doing it the right way. And we also have to make sure that we're just creating documentation to show our work there, right? So aside from that, there are some new, I would say, exemptions, or not exemptions, accredited investor requirements, where we are going to consider people who do not necessarily have the highest income in the world to be accredited investors nonetheless. And really, it's these areas right here. So people who hold certain certifications, people who hold certain licenses for securities. The government has come out and said, it is no longer just a requirement that you be wealthy. It is no longer just a requirement that you be able to sustain the blow of losing potentially hundreds of thousands, if not millions of dollars in value. In these situations, knowledgeable employees of private funds and, all of these people under these series licenses will be allowed to invest in companies as accredited investors now. So this is great news, actually. I do want to make sure that everybody understands that, just because you work for a startup does not mean that you are a accredited investor. Unfortunately, that's not the way it works. For us, we as lawyers technically fall under, a certain exemption as a nature of our practice, and also because we actually do operate other businesses and help other people operate those businesses, such as private funds, like a venture capital fund. But in other situations, though, you have to keep in mind that even the CEO of a company could still be considered a non-accredited investor. The amount of money that they put into the company, the amount of equity that they have is technically, could be considered accredited or non-accredited based on that person's net worth, right? So, and then there's an expanded list of qualified entities. I won't get into this too much, but they actually clarified one aspect of this, which was, companies that are formed for the specific purpose of acquiring securities being offered. Technically, you can't count yourself just as an accredited investor by virtue of that. That said, what is true and where the arguments really come into play here is, let's say, for example, that a business was formed for the specific purpose of investing in another business or investing in general, right? And all of those individuals are accredited. The underlying investors, the underlying members of the LLC are accredited. In that situation, yeah, like the entity itself will have will have what's called accredited investor status, or at least that's what we thought previously. This rule right here, it seems to us, may actually counteract that previous interpretation by saying, no, you have to have more than $5 million in assets. From an opinion standpoint, we have to look at this rule for what it says, and really, it's creating this $5 million threshold, and then it says, for the specific purpose of acquiring the securities being offered. Anyone could argue, really, that, hey, I didn't just create it for that purpose. It's not in the operating agreement that it's created just for that purpose, right? And so there's a situation where everybody's just creating plausible deniability by leaving the purpose language of an operating agreement for an LLC completely open. And so while they might have thought that this was clever, it's not. While they might have thought that was, a reasonable solution to this, I don't think it really solves that problem, because what it does, it creates an additional interpretation issue where we have to sit there and say, it was not formed for the specific purpose of, acquiring the securities being offered. By the way, if somebody was ever trying to prove this sort of thing, which I don't know why you would be, so for instance, in court or something, to prove that somebody wasn't an accredited investor or that they blew up their exemption because they didn't follow this rule, the argument goes, well, you could never prove that they only did it for that purpose. Yeah, I mean, I guess it's reasonably likely that in a lot of cases that would be the case. But at the same time, I'm sitting here saying, no, I can start an LLC and do whatever the heck I want with it. As a matter of fact, I could invest in securities and start a deli if I wanted to with the same exact entity. As a matter of fact, I've actually seen people do exactly that sort of thing, which I think is dumb. But at the same time, you're, what you do with it is completely what you want to do with it. I think what they're really getting at here is, it's going to be up to some sort of case law or some sort of interpretation at some point where the SEC is going to have to issue a guidance letter and basically say, this really means that the specific purpose, has to be something tangible, has to be something that has already occurred. It cannot be something that has not yet occurred, which to me is not what's in that sentence. So this is a small issue, by the way. I don't know why I'm talking about this so much, but the truth is, like, this is just an example of how, they expand the rules or they tighten up the rules, or at least they think they are. But really, the more you draft into this, the more ambiguity you might create. So I would not, I'll tell you, a lot of people who are setting up LLCs for the specific purpose of making an investment in something have no idea that this is the new rule, by the way. So it is what it is. But also, family offices, other types of entities that have excess of $5 million, right? So does anybody have any questions about that? There's some pretty nuanced issues when it comes to accredited versus not accredited. And, going back to what I said about the, previous, going back to what I said about the previous thing with the CEO being a non-accredited investor, when you're looking at, that we do have to factor that into Rule 506B and potentially even Rule 506C calculations. A lot of people have yeah, go ahead.
Oh, sorry. I just wanted to quickly interrupt you. We have a few questions
Okay.
in the comments that I wanted to just flag by you.
For sure.
The first, it says from Nish, in terms of company formation, is it better to start with as an LLC when bootstrapped and the money is all from the founders and then convert to a corporation as you are preparing to raise external capital?
I find that it's actually just easier if you start out as a corporation to start. And the reason for that is if you are going after capital later, and you foresee that somebody is going to demand that LLC convert into a corporation, then at that point, what's a few hundred extra dollars in the grand scheme of things, right? Keep in mind, I actually charge more to convert an LLC to a corporation than I do to set up a corporation in Delaware. And so having that in mind, and there's a reason I priced it that way. I want people to stop taking the approach of cheapest way to do this now and then pay more money later. You really need to be thinking, long term from the gate, from the jump. And so, and I'll tell you, it's very easy to shut down a corporation as well. I think there are a lot of other people who would say, like, yeah, just start the LLC and then convert it later. There are some issues with that, and the problem is you got to get certain approvals, and also most people are not setting up an LLC from the start with the intent of making it easily translate into a corporation later. That said, I will tell you, an LLC will make more sense if you're expecting the business to be very closely held for a number of years before, and you don't want to have to follow any formalities, and you're not expecting to take investment, right? Because a closely held corporation is run pretty much the same way as an LLC is. Instead of bylaws, a closely held corporation can just get by with a stockholders agreement. And the stockholders agreement will look identical to a long form. It will look identical to a long form operating agreement. The difference, though, is you're not going to have bylaws, and you're potentially not going to have other documents that go into it. So I would say that, don't. It's not cutting the corner if you do start with an LLC, and it's not the end of the world which way you go with it. But you do want to make sure that when you're planning out, the ownership of the LLC, that actually easily translates into, the ownership of a corporation, if that's what you're intending to do. That said, if you're looking to that right now and you're like, I'm gonna have to do that later, why not just do it now? That's how I look at things, because skip the step. And here's the difference in cost, by the way. I charge $1,000 plus filing fees to set up an LLC, right? I charge $3,500, which is inclusive of all of the filing fees, to start a Delaware corporation and domesticate it in Texas. I charge, really more like $4,500 to convert an LLC into a corporation, because it is, in fact, always more time intensive than I ever anticipate. And we just have to control for that. You've already got existing agreements. It's already, your structure could be complicated, and you could have actually done, some investment activity before. I find that it's just so much easier if you're going to do it, make sure that you basically create the same, stock structure, but you make it, the membership interest of the LLC. I would just say that you are. I would just make sure that if you're going to start with an LLC, make sure that everything would almost translate one for one over to the new corporation when you do the conversion. But yeah, kind of a long-winded response, but I know, maybe that's not the answer people would want to hear, but in my experience, it doesn't make any sense for you to do an LLC when you just need a corporation a year later. So. Yeah, that was a good question, actually. What about, were there any other questions?
We have one more question from Sarah.
Okay.
She said, what about helping companies raise capital that you don't work for?
I guess specifically, is that question about, us helping people raise money, or is it about, that person who's working for another company, like as an officer, or some other service provider helping another company raise money? Because there are some issues with either situation. So the former situation where, if we're helping other companies that we technically don't represent raise money, I will tell you, like, I don't really have a ton of time to just, hand out, free legal services, or do a lot of stuff that's just, hey, I'm going to help you do this just because I like y'all. My day is, pretty jam packed. I work, 12 to 16-hour days, so I can't really do that a ton. And also, I've got to worry about whether or not I'm helping a company that is in direct competition to another company. In other words, I'm worried about whether that creates a conflict of interest. The other side of that coin, what I said, the latter situation where an officer of one company wants to serve and help another company, with their fundraising. Well, in that situation, I'm not entirely sure that you would want to do that. Number one, you do have to make sure that you're not violating a non-compete agreement by doing that. Number two, you do need to make sure that you're not violating any fiduciary duty you might have if you were, CFO of that company or COO, right? If you serve as an advisor to that company and you've gotten certain approvals for it, et cetera, and you are helping them fundraise, I would highly recommend that you get compensated for it. The time is money, but also, the value you're providing, if those investments do actually go through, is extremely significant. Some of the people who you will be helping do that, your fundraising efforts will quite literally turn them from a multi-thousandaire into a multi-millionaire tomorrow. Why you wouldn't want to get paid for that is beyond me, unless you just really like those people. But aside from that, when it comes to when it comes to fundraising, I always suggest, make sure you're getting, paid in some way, or, make sure that you are actually, make sure that you are, receiving equity in some form for that. So, yeah. Were there any other questions, related to that, or was that it?
Sarah just added a few details to that question.
Okay.
She said she meant as an individual that is asked to help a company raise money who you don't work for. Is it legal?
It technically is legal, yes, but you do need to keep in mind that you don't want to give off the impression that you are creating the situation where hey, I'm working for one company, they're expecting me to provide service to this company, and then you update your LinkedIn profile and it shows that you're helping this other company raise money. Yeah, I mean, you can do that technically. You can do it unpaid if you want. That's perfectly okay. I don't really see anything wrong with it. I would be cautious about doing that, and make sure that you read your employment agreements, read anything that speaks to non-solicitation, non-compete. Because if you're going after the same investors, if you're going after the same people that you got in touch with when you were doing previous activity with your other employer, you may be creating some issues. You may be stepping on some toes that could get you fired from your paying job. So that said, though, I don't see anything wrong with that if that's what you want to do. Okay. Yeah. Aside from that, were there any other questions related to that or anything else?
Nope, you are good to keep going.
Awesome. Thank you. So, I mean, really, I'm going to go through the steps pretty quickly here with respect to, filing certain securities filings. Really, this is a step for your lawyer to do, but I'm bringing it up because I want you to know what you should expect from, your startup attorney when they are doing this. Step one, that person is probably going to have you sign what's called a limited power of attorney, for securities filings. Effectively, what that means is, you're going to give somebody the ability to step into your shoes. You're basically going to allow them to represent you as if they are you, and go file all the securities filings that you need to get done, so that you can comply with the law. And the first real step is get a Citral index key. It's kind of step one or step two, depending. Really, these first two steps are interchangeable. Figure out the deal terms and get your deal docs drafted. This is something that some people don't do, and I find that it helps. It helps at least with having the conversations, when you're early on in fundraising, to actually have the instruments drawn up, to have the term sheets drafted, to have everything else compiled and ready to go, right? With respect to the different instruments, obviously some of y'all have heard these names before. You can do safes, you can do convertible notes, you can do stock purchase agreements. Safes and convertible notes are very, 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 very similar. You don't really, I'll say safes are probably a lot more common now than they were previously. But at the same time, convertible notes are still getting drafted, though they're falling a little bit by the wayside from what we can tell. And I sometimes say things that sound like, hey, this is typical or something like that. Keep in mind, I mean, we're doing what we do for our practice. Each deal is different, so we have to make sure that when we say things like we don't see a lot of convertible notes, or we don't see a lot of this or that, other people might be doing tons of convertible notes because that's what their customers are really comfortable with. I think anyone, though, is going to know what all of these are. Other instruments though, like warrants, stock options, some people will contract when they do a stock purchase agreement or a safe or convertible note. They'll contract for a warrant. They'll contract for a stock option, and the reason they'll do that is so that they hedge some aspects of the convertible nature of safes or convertible notes, so that they at least have an ability to increase the lot of their stake in a certain amount in a way that they can tell is, okay, hey, based on the purchase price of this warrant, we will have made or based on the strike price and the agreed upon purchase price of the stock options, we will end up making X amount if we end up exercising the options later on. So other things to keep in mind: a term sheet can be really helpful, subscription agreement, wire transfer information pages, and accredited investor questionnaires, all good stuff to have. Down at the bottom, I say side letters here. I'm not sure if anyone here is super familiar with side letters. So let's say, for example, that we had these top 5 things drafted out here, right? But let's say, for example, that we've got another sort of we've got either a separate transaction that is not similar. We've got our standard transaction that's a safe, but these people do want warrants or they do want stock options. Well, the warrants or the stock options, the agreement for that is going to be different than these other transactions is going to be incorporated into this side letter. And the side letter is going to allow them to get different terms, is going to allow them to modify certain terms that other investors might not get. And we usually see side letters where we're varying the terms based on what's been negotiated, and we're going to see side letters where we are creating certain rights that others are not going to get. So for example, let's say we're raising $1 million round and somebody's putting in $500,000. Well, obviously the person who puts in $500,000 is going to probably get anti-dilution. Though I'm going to bet money that the instruments that are up here do not contemplate anti-dilution, right? And there's a reason for that. We don't want these initial instruments to contemplate things we don't want to give to everyone. We want to have those other things in the back pocket. We want to make sure that we are not giving them, we're not giving everyone the most preferential terms, because we don't want to go out there and do, a 25% sale of a company and, have anti-dilution all the way in there. And then you go, oh crap, like the next time I go raise money, like these people are not going to be diluted at all when we issue. So we're going to have to issue additional stock to them, as well as additional stock to the new investors. And the new investors are probably going to look at the old investors and go, I want anti-dilution. So you do have to keep in mind that we have to make sure we're controlling these factors in such a way that we create, you don't want to create precedent that will always be relied upon, but you want to create, the sense that not everybody is going to get the same deal, especially not in the future. Right? Because we won't do the same deal every single time. We won't give anti-dilution every single time. And you do have to press certain people to get creative. Do we have any questions about that? Because I did talk about that a little bit more in depth. Aside from that, important deal terms to focus on here, don't modify the discount rates, I would say, in safes or convertible notes. We're going to see 20% on those pretty much every single time. I have never actually seen a safe or a convertible note that was different. Interest rates, try not to go hog wild with the interest rates. They can get really high. Also, you need to be, certain that the interest rate being put in there is not usurious based on state law. It can be in certain instances. So to give you an example, in Texas, let's say we had a Texas governed convertible note agreement. And let's say the interest rate in there was, 28% or something like that. That'd be extremely high. I would never agree with it. But let's just say hypothetically, somebody who came to me didn't know that and had that in their agreement. At that point, I could just straight up look at it and say, that is, illegal as a matter of law, basically. And then we would have to go into the statute and figure out how to fix it. And, whenever, we do the calculation for shares upon conversion, or whenever that person decides to get paid out at some point, we would probably have to, we would probably have to basically tell these people, hey, you're not getting that interest rate because that interest rate was illegal. At which point they'll probably accuse the company of contracting in bad faith. At which point I would say there's no such thing as, contracting in bad faith when you agree to, or when you try to subject us to an illegal interest rate. Anyways, so valuation caps. I saw an opinion the other day that most people believe that valuation caps benefit only the investor, especially when the valuation cap is a post money valuation cap. Keep in mind that I know some people, and I was reading this from another law firm that's based in Austin, and I thought this was an interesting take on this. When it comes to valuation caps, these people said that they did not want to ever include, a valuation cap because it was actually antithetical to the entire purpose of the purpose of a safe or the purpose of a convertible note, which is to say that the value of that instrument should be, relatively unknown until the time of conversion. And that's really what a post-money valuation cap does. The post-money valuation cap provides basically a way for the investor to triangulate its investment, to triangulate the value of it. And so, we look at these things and, we sometimes say, no, we don't want to include them. And also the valuation cap, if you set it too low, if you experience a lot of growth, then you could potentially be creating this situation that, the valuation or the valuation cap could injure the company when the conversion happens. There's some algebra that goes into that, but there's some literature that's written by Brad Feld and some other people who specialize in the deal points here and the mathematical terms, and they talk about all of that. So aside from that, though, average, we see for the next equity financing, we usually put those terms around 500 or 5 times. So, for example, if you're raising $200,000, we'll put the next equity financing at $1 million investment amount. The reason for that is, if you have raised $200,000, then you've raised quite a lot of money, and we can reasonably expect, 2 to 3 years from now, maybe even, closer than that, that you will need a minimum of $1 million to keep going, or that you would want to raise a minimum of $1 million to keep going. It can be lower or higher, depends on what's negotiated, depends on what the client and the investor want. Obviously, we are not going to sit here and say, that's it, that's all it ever is. If somebody asks for it to be different, we will work with them, but we do have to make sure that we're not telling people, hey, this $200,000 investment, I'm going to set the, next investment amount at, 100,000. I mean, unless of course I'm getting told by the company that this is literally all the money we're ever going to need. We're going to make that amount higher because, I want the investment amount to both be attainable there for the next equity financing, but also to be high enough so that we're not triggering it, immediately. So, does anybody have any questions about that? Step 3 here: find investors over the next 12 months. From the time you open a fundraising round to the time you close it, you have 12 months. There really is no wiggle room for that, though. If you look at some startups in Silicon Valley, it appears that they're just ignoring this rule. That's always been a bit weird to me because I know for a fact that those companies that are raising money in San Francisco and the Bay Area are indeed, filing the securities filings because they have to. Some of them I actually know they are not, and I'll get to that in a minute. But like, when it comes to this rule, you'll see people who are almost perpetually raising money. Like, they'll raise money for 3 months, then go back into the market 6 months later, and go, oh yeah, we raised a seed round, now we're raising a Series A. You're technically not supposed to do that because it could potentially lead to what's called integration of a fundraising round, the idea is, you're supposed to be, in the market for no more than 12 months in a continuous period. You have to take a break at some point. That said, there is some way, to look at things. The idea is, let's say we raised money over a month, and then you waited 8 months, and you decided, hey, we're cash strapped. We don't raise money. This thing is gonna have problems. At that point, we've got to make a decision. Does it make more sense to comply with the law, or does it, make more sense for us to go out and raise money? And pretty much every time we'll say, take the risk on getting the round integrated. We don't really care about it at that point, because you have, investors who you have a fiduciary duty to, as well as potentially employees who are making money off of the work activity that you're doing, the business itself, and you want to make sure that those people have a job. Those are all, in my opinion, valid reasons for going against the rule there. And it probably sounds odd to hear a lawyer saying this, but the reality is, in some cases you have to do what you have to do in order to make sure that you are doing your job. You can call it, a different fundraising round. The SEC can integrate them if they want. It probably wouldn't be the biggest deal in the world if they did, so long as you have complied with, whatever securities law exemption, for both rounds, right? So, and like I said before, just make sure you certify that these investors are accredited. Make sure they are filling out the questionnaires if they have to fill them out. Ensure that funds transfer to the company. It's essential when selling securities that these things be funded in the exact amount. We have had it happen before where somebody signs an agreement for not a lot of money, and then they decide after the fact that they don't really care for that company, and instead of paying whatever amount they're only going to pay 10%. At which point, I've got to sit there and say, ask the client, do you actually want that money? Because quite frankly, they're telling you that they're breaching this contract. That's a serious deal. Like, I can actually take people to court and get them to specifically perform on that agreement. I can literally have a court say, no, you agreed, pay them. And the court would order it 10 times out of 10, because there's nothing else they would be able to do. That said, obviously it is not a good thing for an early stage startup to go out there and be threatening its investors. Obviously that's a massive red flag, and we would never want to do that. So the clear alternative is either amend that agreement or just cancel it altogether. And actually, the way I would recommend doing this is, if some of you have raised money before and this hasn't been the case, maybe consider doing this. I go back and forth on whether I want to do this, by the way. And I'll go through the pros and cons of it right now. Sometimes we include language that says, in the event you don't pay us within 30 days, the subscription, for the round is void as a matter of this agreement. And then, they won't be entitled whatsoever to any of the stock or any of the securities that were being sold. And that's, a clean way of making sure that, hey, these things fund within a reasonable amount of time, and also eliminates any extra steps that I, as a lawyer, may have to take with respect to the investment. That said, there is, always an alternative argument to that sort of thing. So let's say, for example, we don't include that language. There is, a reason why I wouldn't. And it has to do with the fact that, no, you're not getting out of this without, we didn't sit here and court these people for 4 months and then finally get them to sign on the dotted line and cut a check for them to not cut the check, right? It's not that we twisted their arm or put a gun to their head or anything. It's that we literally, had an expectation that we were going to receive this money and did not focus our efforts on it, on anybody else. And if you're sitting there focusing your entire effort on, 1, 2, maybe 3 individuals, that's a lot of lost time. That's a lot of lost time when it comes to that 12-month rule. And it's a lot of lost time when it comes to when it comes to the money that the company could have made, because the other investors who've already put money in are hoping that you build this company so quickly that it goes 10x, it goes 100x. So there's a pro and a con to everything when it comes to what we do here. And but the other thing I want to say is don't let it go. Let's say, for example, you have somebody sign a document and they never put money in. At that point, you are absolutely going to need to address it. You are going to need to ask them, do you want to invest? If not, you're either going to need to draft one or more things, a termination agreement, or you're going to need to notify them that the investment is now void as a matter of the contract because of the language that I just talked about. Other ways to do this, by the way, to further, I guess, it can protect the investors, but it can also protect the company and the people who are managing the money. You can engage in, escrow arrangements. So let's say, for example, you're raising $10 million. And, the early investor who puts in $1 million doesn't want to be the only investor. And so what they end up saying is, I really do just want to, I'll put in this $1 million, but you got to put it in an escrow account. I mean, contingent upon raising $2.5 million, at which point you can take the money out. And, the investment will be considered, like it's going to close. It's just a matter of whether you actually reach 10 million. And so I would just keep in mind that there are other ways to do this in order to make investors comfortable. There are other ways to do this in order to protect yourself. And so this is not, an exclusive or an exhaustive list of how we do this. In some cases, we actually don't have, subscription agreements. We just have somebody sign, an operating agreement, and then they put the money in. Not everything needs to be a super intense, procedure. But when it comes to early stage tech companies, we always do make sure we're checking these boxes, because at some point in the future, if you ever do go public, they're going to want to know that you did everything right. And if you do have a lot of investors, you don't want to be in a situation where, anybody who has a real claim to be made is making it when you're about to IPO. So, and then, step 5, update Reg D, other securities filings once round is closed. Follow up with any post-closing procedures. Make sure you implement, a plan for following up with your investors, which is very key. There is software that will allow you to do that. There is technology that will allow you to, notify investors of certain activity. And you will, as you grow, if you don't have, somebody installing themselves as a member of the board, we're going to have to get someone, you're probably going to have to loop people in on the annual meeting. You're probably going to have to loop people in on any of the board meetings that maybe happen, maybe let them observe or something like that. Aside from that, do we have any questions from this last stuff? Have I said anything that anybody might have asked about? Okay. Well, if you do have a question, please let me know. Aside from that, I'm going to just keep going on here. So, like I said, I've already talked about the continuously raising money thing. I would say just don't do that. At some point, you do need to figure out like whether your company can truly make it without having to have constant capital infusions. That seems counterintuitive, but at the same time, we don't. Like even with companies that have gone IPO, they are, in other ways, raising money through debt, through, other equity type of financing. But you really want to make sure that you're not like continuously raising money as a privately held startup, because one thing it does show is that, you're sort of running the thing, well, it does show that you're spending money fast enough and really growing really fast. But one thing it can be is a negative. It can be a signal to people that we're not sure if this thing will ever, have enough value to see itself through to an exit, right? Because it's just burning through cash too quickly. Aside from that, can you personally guarantee investments? No, you can't do that. That's not the way this works. As a matter of fact, the entire the entire law around this is designed for you to it is designed for your investors to take these risks. Even with publicly traded stocks, the same way with private offerings, you're not, allowed to personally guarantee these things. So don't do it. In the event, in the event you do it, you probably need to talk to a lawyer about it and figure out how to fix that. Okay. What's the best time for my startup to raise money? Beats me. You've got to figure that out on your own. The CEO of a company will know whether or not that person can personally capitalize it or not. If you can't personally capitalize it, your business is going to need money, or you're not going to have a business. So if you need capital, go get capital. Go raise money if you have to. Not every business needs a ton. Not every business needs. Not every business needs to raise millions and millions of dollars. Some people can get by with a small amount. So, and actually, I do have a few minutes for corporate governance. And so I do want to go through this because I haven't been able to previously. So let's talk about this. So really, when it comes to corporate governance, most private companies do not focus on this. And you don't need to, be, hey, the strictest corporate governance person on the planet, because you obviously want to make sure that you're doing things the proper way, the right way, but you don't want to come off as totally inflexible, as totally incapable of making a decision without having a board meeting, right? So, make sure that certain duties are delegated to certain individuals. Make sure that their responsibilities are their responsibilities. But also make sure that you are, holding an annual meeting with your investors. Make sure, you're disclosing certain things at certain times, right? Please make sure that you are, following the law with respect to these corporate actions that you might be taking. Because, there are situations in which you will take a corporate action, and if you didn't provide for something in the bylaws, if you didn't provide for something in some other document that allowed you to do that, and it was not waivable by statute, then you can very well be violating the law in a way that might require you to either fix it or terminate the business. And so just keep in mind that, and back to the question about LLC versus corporation, right now, or do I do it later? The truth is, a corporation is typically going to have a more stringent set of corporate governance measures that have to be taken every single year. You don't really need to worry so much about you don't really need to worry so much about that with LLCs, because LLCs are designed with flexibility in mind. So just keep in mind that you are not really wanting to keep in mind that if you are starting a corporation, that you are going to have to follow these rules eventually, that are going to be a little more stringent than an LLC would. Especially once you get investors in, there's really no getting around these anymore. So board resolutions versus stockholders resolutions. Some questions come up as to what makes sense and when here. In some cases, the board will recommend something to the stockholders, or the stockholders will recommend something to the board. Is there a difference, really, right? And is there a board of directors for the company? I will tell you, typically, what we do when we start a Delaware corporation, I make the founders of the Delaware corporation the board members. Or what I do is I make sure that the board member that really needs to be in charge and really needs to have the veto over everything, and the say over the day-to-day business operations and anything that really is material, I make sure that that person is in charge, and placed as the only board member in some cases. That really is it goes to protecting the company, number one, but it also goes to protecting the interests of the people who have founded the business. They are interested in maintaining, their stakes. They are interested in maintaining what they have built. And we don't want to be sitting there creating a situation which can just result in board deadlock. We don't want to create a situation which makes it so that nobody has, an executive decision, and that everything must be, decided by committee. That said, certain things must be done with stockholders resolutions. For example, let's say we are issuing, stock in for an equity incentive plan, otherwise known, colloquially as an employee option pool. With employee option pools, you got to approve those by stockholder resolution. Usually, they send a board resolution as well. But really, the most important aspect of it there is the stockholder resolution. You have to do that, because if you don't, then you've created an authorization of stock, and in a way in which you're issuing it without consulting the shareholders. So that's extremely key. And other decisions, such as a sale of a majority of the beneficial ownership of the company, most of those decisions are, if you sell the assets of the company, if you sell the majority of the assets or the entirety of the assets, or you sell the stock or the majority or the entirety of the stock, you are going to have to do that by stockholder resolution. And usually we would prefer to see majority language in the stockholders agreement with respect to that, so that we're not running into a problem with, hey, do we have to get unanimous approval? I actually did see the other day, I did a $350,000 real estate investment down in Houston the other day, and in order to get it done, we literally had to we literally had to get unanimous consent from all of the members, and there were like 10 of them. And that's really not ideal. So we changed the language to say just those who own a majority of the membership interest, which amounts to 2 or 3 people. There's a lot less friction when we do majority language. We do super majority language, but keep in mind, we don't want to make it so that whoever controls a large majority can basically block the company's activity, because it could really cause some problems. Aside from that, you're going to be signing, unanimous written consents or written consents by majority of these people. Common ones: the initial organization incorporation, of course, really standard stuff. Grants of stock can be a little bit different. Sales of stock can be a little bit different. Hiring or terminating board members, hiring, terminating officers, service providers, and major transactions too. You got to make sure you're papering those up with a resolution once you're big enough. And then meetings of the board of directors and stockholders. Most states have a statute stating that you have to do this once a year. Technically, it's not something that requires that you wind up the company if you don't do it. And actually, the statutes will say that. So if you look at, I believe it's here's the example: failure to hold an annual meeting does not result in the winding up or termination of the corporation. Reason being is meetings get rescheduled, right? If you have, hey, you got to meet on July 31st of every year, and you end up having, let's say, you have a family emergency for some reason. Well, of course you're going to miss the meeting, right? Maybe they'll push the meeting. We would never roll the corporation up for that reason. So, but the reason we hold, the annual meeting is because these people who are passive investors, these people who are passive stockholders, really need to be kept in the loop on the activity of the business, and really need to be told, here's where it's going, here's what we're doing, so that they can understand, at what point are they going to get out, or at what point are they going to, have a right to exit, their investment. And then, what to do at these meetings, by the way. This is not really that often talked about, but I will tell you, as lawyers, we sometimes, attend these meetings or conduct them ourselves, and basically call the meeting in accordance with the bylaws. And then we'll take notes, basically serve as the scribe for that meeting, or basically the secretary. And then we will take the, meeting minutes, boil them down, have the secretary sign them. And then we will, anything that requires a resolution, we'll draft the resolutions for that. And those are important meetings, especially with bigger meetings, but it does come up sometimes. So to give you an example, the only company that has really ever failed that we have ever advised, I held the meeting I mean, I helped hold the meeting where I asked the the only four shareholders of it, hey, it's time to file for Chapter 11 bankruptcy. I just need to know whether or not you're voting yes or no. And then I asked them, do you vote yes? They said yes. I asked this person, do you vote yes, or do you vote no, or something along those lines. You have to ask it in a pretty particular way where it's definitive that you said, I mean, like the yay or nay, basically, and they have to tell you yay or nay. And they basically have to take turns in that situation or raise their hands and once the question has been posed. And so, and then you have to, adhere to the timelines for notice. I will tell you, though, certain provisions of bylaws, certain provisions of operating agreements allow for waiving notice in some cases. And, you can waive notice if you just attend a meeting. If you didn't receive notice of it and you attend, you can waive the fact that you had never received that notice. So keep in mind that you could be forfeiting certain rights as a stockholder or, a member of a company if you, attend a meeting and don't dissent in writing or don't dissent to the failure to give notice in writing, in compliance with the operating agreement. So your goal there is, obviously you don't want to be hostile to the people who are super hostile to the people who are, co-shareholders with you in a company. But at the same time, you got to protect your interest and make sure that you're holding a meeting the way you should be. So tips for this as your company grows. This is the last slide. As far as this goes, begin holding board meetings, stockholder meetings, try to do this regularly and try not to let it go. As you grow, though, some people are going to not just ask you to do this, they're going to require it. So let's say you get major institutional investment from a venture capital firm. If that entity is taking a board seat, you can bet you could bet all the money they've invested that they are going to require formal board meetings, that they are going to require resolutions for all the decisions that are being made. And so, even if you haven't taken investment, you should still conduct these meetings if you have more than one founder or shareholder. The saying goes, if it's just you, kind of difficult to have a meeting with yourself. But with respect to, resolutions themselves, you should still be, doing things with resolutions that are in, that are in lieu of an organizational or in lieu of a special meeting of the shareholders. So or an organizational meeting of the board of directors. So not really as important for single member LLCs or single shareholder companies, but still important that you get the resolutions down on paper. So I believe that is it for today. And I believe we're, at 5 minutes over time. Do we have any questions before I go? All right. So in that case, hey guys, we will be here, same time next month, 10 a.m. first Tuesday of the month. Feel free to join us for Startups in the Law once, if you're interested in learning more about this stuff. We'll be doing different topics next month. Take care, guys. Have a good rest of your week. Bye.